Political crime, criminal classification. Political crime refers to crimes committed or acts omitted that injure or are perceived as injuring the state, the state's government, or the political system. 1. Political crime. 2. Examples of political crimes. Political crime refers to crimes committed or acts omitted that injure or are perceived as injuring the state, the state's government, or the political system. It is the attempt of the citizen to injure the state, at least in the state's eyes. Political crime is defined in contrast to state crime, which refers to criminal acts or omissions of the state itself, typically those against its own citizens. Examples of political crimes. States will label any behavior a political crime that is perceived as a threat to the state's authority and/or continued survival, regardless of whether the threat is real or imaginary. Some examples of severe political crime are treason, sedition, terrorism. In some more repressive regimes around the world, actions such as publicly speaking out against the government or supporting ideas that the government condemns may be seen as political crimes, and punished severely. Crime does not have to actually and directly threaten the security and integrity of the regime to be labeled political. For example, the vehement advocacy of change in the ruling order may be considered a political crime, or the demand for change in long-established policy, or a simple act that signifies disloyalty like burning the nation's flag. Violence or prejudice. Discrimination against minority groups, trade union strikes, or picketers can also be perceived as political crime when those in power regard it as undermining the political integrity of the country. Crimes against the person. Crime against the person, often simply referred to as violent crime, is arguably the most serious species of crime addressed by the criminal law. Crimes against the person. Crime classifications. Crime against the person, often simply referred to as violent crime, is arguably the most serious species of crime addressed by the criminal law. Homicide, rape, assault and battery are all considered to be crimes against persons. These violent crimes have the potential to incur the heaviest punishment dealt out by the criminal law, up to and including the death penalty in this country for the most hateful offenses. Only a few other crimes incur penalties as heavy as crimes against the person, for example, the political crimes of high treason and grand espionage. For the purposes of criminal law, person refers to the health and integrity of the body, as well as the freedom to move about willfully. Any attempt to wrongfully harm or wrongfully imprison another person is considered to be a crime of this type. Certainly, deliberate violence done to a person can count as crime against the person. But actual violence isn't necessarily required for something to be a crime against the person. Someone who acts aggressively and threateningly, as if to make someone else believe they're about to be attacked, might be guilty of a crime against the person. Assault, in this case. Someone who tries to administer a lethally poisoned drink could be guilty of a crime against the person. Attempted murder, even if their potential victim pours the poison harmlessly down the drain. And someone who takes an unwilling hostage and demands ransom is probably committing a crime against the person. Kidnapping, even if the prisoner is treated with the utmost courtesy and care. Nobody was physically harmed in any of these examples. But threatening or attempting harm, as well as robbing people of their liberty, can qualify as crimes against persons by the criminal law. Crime is an offense against society as a whole. But the fundamental composition of society is its members. This is why crime directed at the health, life, or liberty of any member of society is considered by most people, and the law, to be the most heinous species of criminal activity possible. See also, felony, misdemeanor, infraction. Crime against property. Crimes mala in Southeast. Crimes mala prohibited. Corporate crime, criminal classification. Corporate crime refers to criminal offenses that are either committed by a corporation or by an individual or individuals who represent corporations. 1. Corporate crime. 2. Types of corporate crime. 3. Prosecuting. Corporate crime refers to criminal offenses that are either committed by a corporation or by an individual or individuals who represent corporations. There is often an overlap between corporate crime and white-collar crime, state corporate crime, and organized crime. The common practice among criminal organizations is to set up shell corporations for the purposes of committing crimes or for laundering the proceeds of crime. Types of corporate crime. Corporate crime generally takes one of two forms. First, a corporation may be established expressly as a vehicle for crime. This usually occurs in short-term operations, in which the founders of the corporation assume the airs of a legitimate business, luring unsuspecting investors in and then making off with their investments. The second and all too common form of corporate crime occurs in already established corporations, blending into regular business operations in a way cleverly designed to conceal illegal activity. Examples of this include profitable but environmentally damaging practices, e.g., illegally dumping toxic waste, exploitation of workers, and fraud of every kind, usually at the expense of consumers. Prosecuting corporate crime. Corporate crime can be difficult to prosecute effectively. First of all, 19th century Supreme Court ruling Santa Clara County v. Southern Pacific Railroad 118 U.S. 394 1886 has been cited in many cases to assert that a corporation can legally be defined as a person, which allows corporations to claim Bill of Rights protections in court. Further, the 14th Amendment holds that no state shall deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The fact that corporate crime is often well concealed, and that corporations can, as a rule, afford to hire legal counsel of the best quality complicates criminal procedure, impedes justice, and makes it exceedingly difficult for public prosecutors to establish guilt beyond a reasonable doubt. Furthermore, the state derives a great deal of its stability from the health of the many corporations that operate under its jurisdiction, particularly the large ones. The revenue generated by profitable corporations makes up or contributes significantly to the health and power of the government. Imposing a meaningful punishment on a corporation for its crimes, for example, the $100 million fine, could devastate many large corporations, which could in turn hurt the government and, perhaps, society as a whole. This creates a serious conflict of interest in prosecuting corporate crime, since the state's responsibility is at once to protect its citizens from harm and to ensure the financial health of the businesses operating within it. Can a corporation be charged with a crime? Can a corporation be charged with a crime? As legal entities, modern corporations can be charged for the crimes they commit. 1. Common types of corporate crime. 2. Penalties for corporate crimes. 3. The decision to prosecute. 4. Sanctions. 5. Conditions of finding the corporation guilty of a crime. 6. Knowingly engaging in crime. 7. Even if the owners don't know, can a corporation be charged with a crime? As legal entities, modern corporations can be charged for the crimes they commit. They can also sue others and be sued, though historically, this was not the case. While they're independent entities, corporations can't act on their own behalf, so one of the corporation's agents, like a director or board member, has to perform any actions. When the action is done within the scope of that person's employment, then the corporation can be held liable for what the agent did. Common types of corporate crime. The prosecutor has to prove what was done illegally, that the agent of the corporation acted as part of his or her duties, and that it was done with the specific intention of providing benefit to the corporation. Corporate-level crimes are often white-collar offenses, such as antitrust violations, corporate fraud, securities violations. Another common corporate crime is environmental, especially for manufacturing corporations in industrial settings. Penalties for corporate crimes. One of the most effective ways to punish the corporation for corporate crime is by assessing a monetary fine and making the corporation pay restitution to the victims. The corporate agent, however, might face prison time for the crimes. The decision to prosecute. The decision about who to charge, whether the agent or the corporation, falls on the prosecution. The prosecution does have the option to press charges against both the corporation and individual agents involved. However, the prosecutors are also required to prove which entity committed the crime, and they are also required to prove each detail of the crime beyond all shadow of a reasonable doubt. Sanctions. The process of deciding to charge a corporation with a crime is similar to the process of deciding to charge an individual with a crime. The prosecution sifts through the information and details, considering things like whether the evidence is sufficient, whether the case would likely succeed if it goes to trial, and past crimes and unethical behavior the corporation might have committed. Sometimes sanctions, which are not criminal penalties, might be imposed. Conditions of finding a corporation guilty of a crime. Even though corporations aren't people, legally a corporation is treated as if it were an individual in some cases. The corporation can be held liable for and found guilty of a crime if the corporation's agents do something criminal while working, are responsible for the details of the crime, and commit the crime in question for the profit of the corporation rather than for their own profit. knowingly engaging in crime for a corporation to be found guilty of a crime. Every detail of the crime has to have been committed by the corporation's agents. The prosecution has to prove the corporation's agent, or agents, knowingly engaged in each of the crime's elements, if more than one person acted illegally on behalf of the corporation. When dealing with a small business, this is usually fairly simple. As an example, if one of the small company's workers uses poor quality parts that were purchased by the business partner, with full knowledge of their substandard quality, then both the person who purchased the substandard parts and the one who installed them are performing a fraudulent act and are standing as agents of the corporation when committing the crime. Even if the owners don't know if the corporation's owner embezzles from the company, the owner benefits from committing the crime but the company doesn't. That means the company isn't guilty of the crime. The owner is guilty of the crime. If one of the bosses, however, has the employees do something illegal, like dumping hazardous waste to save money on disposing of it, then the company benefits and is, therefore, the guilty entity in the crime. The company is guilty even if the owners and shareholders don't know that the manager has done the illegal thing. If the company's agents commit a crime to benefit the company, then the company can still be held liable and found guilty, even if the owners had nothing to do with the crime. If you need help with a corporation being charged with a crime, you can post your legal need on UpCounsel's marketplace. UpCounsel accepts only the top 5% of lawyers to its site. Lawyers on UpCounsel come from law schools such as Harvard Law and Yale Law and average 14 years of legal experience, including work with or on behalf of companies like Google, Menlo Ventures, and Airbnb. Blue-collar crime. Blue-collar crime is a term given to criminal acts more likely to be committed by citizens of lower social class in society. Blue-collar crime. Blue-collar crime is a term given to criminal acts more likely to be committed by citizens of lower social class in society, such as those which inflict direct harm on the person or property of others. This is in contrast to white-collar crime, which is generally committed by citizens of higher social class, who are more likely to be presented with the opportunity to commit such crimes. Blue-collar crime is an informal classification and holds no particular legal weight. For the most part, blue-collar crime entails whatever crimes are most immediately possible for a person to commit, those that are most often spurred by passion rather than those that require careful deliberation. Crimes against the person, crimes against property, and many forms of victimless crime such as prostitution, gambling and drug abuse all tend to be classified as blue-collar crime. Blue-collar crimes are, for the most part, those that cause an immediate and highly visible injury to society, so they're usually punished much more rapidly and severely than white-collar crime. Also, citizens of lower social class cannot generally afford high-quality legal assistance, which means they tend to suffer far more severe punishment than white-collar criminals. Citizens of higher social class are certainly capable of committing blue-collar crimes, and do, all the time. However, the vast majority of these crimes are committed by citizens of lower social class, who in turn have limited opportunities to commit white-collar crimes such as financial fraud and money laundering, which is how these classifications originated. White-collar crime. Criminal classification. White-collar crime is a crime committed by a person of respectability and high social status in the course of his occupation. 1. White-collar crime. 2. Prosecution of white-collar crime. 3. Cost of white-collar crime. 4. Types of white-collar crime. White-collar crime. White-collar crime, as opposed to blue-collar crime, is a relatively sophisticated criminal activity in which individuals entrusted with commercial or governmental responsibilities abuse their positions for financial or political gain. The term white-collar crime was coined in 1939 by Edwin Sutherland, who defined it as crime committed by a person of respectability and high social status in the course of his occupation. White-collar crime often overlaps with, but is not strictly limited to, corporate crime, state crime, and state corporate crime. Prosecution of white-collar crime. White-collar crime can be difficult to successfully prosecute. Those who commit crime of this sort are often in a position to cautiously plan out their actions, and tend to operate in areas where they possess intimate and sometimes exclusive knowledge. This cautious planning and in-depth knowledge of their targets often makes it easy for white-collar criminals to conceal or dissimulate their offenses. Furthermore, White-collar crime can often occur under the guise of regular business and political transactions, and there is even an ethic in certain lines of business that encourages professionals to get away with as much abuse as they can without getting caught, an accusation which might be leveled at the entire financial industry, to say nothing of the political arena. On the whole, the criminal law does not hunt down and prosecute white-collar crime with nearly the same vigor as blue-collar crime. Most police forces do not have authority to investigate crime at the white-collar level, and almost no effort goes into monitoring corporate and state criminal activities. This task falls on the shoulders of organizations such as the Environmental Protection Agency and the Securities and Exchange Commission. Furthermore, it is commonly known and resented that those guilty of white-collar crime can afford to hire the best legal defense, or even influence the way the jurisdiction defines and prosecutes crime, so that the minimum punishment will fall on their heads. Cost of white-collar crime: it is estimated that white-collar crime cost the United States from $200 to over $300 billion every year. This is staggering compared to the estimated $15 billion to $20 billion in damages that blue-collar crime inflicts. The problem is, fortunately and unfortunately, these tremendous financial losses are usually spread out quite thinly through the population, making it difficult to raise the kind of awareness and concern that are usually necessary to spark criminal investigation. White-collar crime almost never involves violence against the person or the destruction of physical property, and national consciousness is often barely high enough to realize white-collar crime is going on, let alone experience moral outrage. In a sense, this is a species of crime that victimizes no one and everyone at once. Types of white-collar crime: common examples of white-collar crimes include but are not limited to tax evasion, financial fraud, securities fraud, insider trading, bankruptcy fraud, healthcare fraud, antitrust violations, government fraud, bribery, kickbacks, economic and industrial espionage, money laundering, and embezzlement. Legal definition of entrapment: everything you need to know: the person is entrapped when he is induced or persuaded by law enforcement officers or their agents to commit a crime that he had no previous intent to commit. 1. Exceptions to entrapment. 2. Reasonable doubt and entrapment: the person is entrapped when he is induced or persuaded by law enforcement officers or their agents to commit a crime that he had no previous intent to commit. In such a case, the law forbids conviction. Exceptions to entrapment: however, there is no entrapment where a person is ready and willing to break the law and the government agents merely provide what appears to be a favorable opportunity for the person to commit the crime. For example, it is not entrapment for a government agent to pretend to be someone else and to offer, either directly or through an informer or other decoy, to engage in an unlawful transaction with the person. So, the person would not be a victim of entrapment if the person was ready, willing, and able to commit the crime charged in the indictment whenever an opportunity was afforded, and that government officers or their agents did no more than offer an opportunity. Reasonable doubt and entrapment, on the other hand: if the evidence leaves a reasonable doubt whether the person had any intent to commit the crime except for inducement or persuasion on the part of some government officer or agent, then the person is not guilty. In slightly different words, even though someone may have sold drugs, as charged by the government, if it was a result of entrapment, then he is not guilty. Government agents entrapped him if three things occurred. First, the idea for committing the crime came from the government agents and not from the person accused of the crime. Second, the government agents then persuaded or talked the person into committing the crime. Simply giving him the opportunity to commit the crime is not the same as persuading him to commit the crime. And third, the person was not ready and willing to commit the crime before the government agents spoke with him. On the issue of entrapment, the government must prove beyond a reasonable doubt that the defendant was not entrapped by government agents. Legal definition of probable cause: what you need to know: probable cause is the reasonable belief that a person has committed a crime, and a test is used to determine if it is sufficient enough to arrest a suspect. 1. Arrest. 2. Item Seizure. 3. The Fourth Amendment arrest. Probable cause is defined as the reasonable belief that a person has committed the crime. To determine probable cause, a test is used to determine if probable cause exists and is sufficient enough to arrest a suspect. The test must show that the facts and circumstances of the officer's knowledge are sufficient enough to warrant a reasonable person to believe the suspect has committed, is committing, or is about to commit the crime. Item seizure. When items related to a crime must be seized, the presence of reasonable cause must exist in order to take any contraband, stolen property, or items that would aid in proving the crime has been committed. The arresting officer is expected to assess the situation, and their findings show a reasonable person would see the evidence as valid. The Fourth Amendment. The Fourth Amendment prohibits an officer from making an arrest without showing probable cause. Probable cause is shown to exist when the facts and circumstances within the arresting officer's knowledge are sufficient to warrant a prudent person to believe that a suspect has committed, is committing, or is about to commit a crime. If probable cause is used without justification, a case can be made in both civil and criminal charges. Probable cause is presumed to exist until the contrary is proven, even if the suspect is accused through malicious intent. Any grounds for suspicion that a crime or misdemeanor has been committed must be investigated for the purpose of public justice and for the good of the community as a whole. Legal definitions of malicious prosecution and intentional toward arising from the instigation of unjustifiable and unreasonable civil or criminal litigation. 1. Sheldon Appel. 2. Definition of malicious prosecution and intentional toward arising from the instigation of unjustifiable and unreasonable civil or criminal litigation. An action for malicious prosecution can be brought against underlying cases plaintiff's counsel and/or advisors. Sheldon Appel. In one of California's leading cases, its Supreme Court granted review in Sheldon Appel to consider a number of issues relating to the proper determination of the probable cause element in a malicious prosecution action, including the question whether a plaintiff may establish an absence of probable cause by proving that its former adversary attorney failed to perform adequate legal research before filing the prior action. Sheldon Appel Company v. Albert and Bill Liquor, Supra, 47 calories. 3 pages. 867-868. To that end, the court determined that the most promising remedy for excessive litigation does not lie in an expansion of malicious prosecution liability ID. That page 873, and thus found it was not advisable to abandon or relax the traditional limitations on malicious prosecution recovery ID. That p. 874. It was from that perspective that the court analyzed the specific question presented in Sheldon Appel. First, the Supreme Court determined the issue of probable cause is one for the court, not a jury. Sheldon Appel, Supra, 47 calories. 3d at pages. 874-877. Thus, where there are no disputed questions of fact relevant to the probable cause issue, the matter may be determined by summary judgment or on appeal by de novo review. ID. That pages. 884-886. Second, the Supreme Court determined that, whereas in Sheldon Appel the facts known by the attorney are not in dispute, the probable cause issue is properly determined by the trial court under an objective standard. It does not include a determination whether the attorney subjectively believed that the prior claim was legally tenable. Sheldon Appel, Supra, 47 calories. 3d at p. 881. The perceived and objective tenability of a claim. To avoid confusion, the court strongly emphasized that it did not mean to suggest that an attorney who institutes an action which he does not believe is legally tenable is free from the risk of liability for malicious prosecution. If the trial court concludes that the prior action was not objectively tenable, evidence that the defendant's attorney did not subjectively believe that the action was tenable would clearly be relevant to the question of malice. Inasmuch as an attorney who does not have a good faith belief in the tenability of an action will normally assume that a court is likely to come to the same conclusion, the malicious prosecution toward will continue to deter attorneys from filing actions which they do not believe are legally tenable. Furthermore, the probable cause element, as so defined, imposes improper or unjustified hardship on a malicious prosecution plaintiff. If a court finds that the initial lawsuit was in fact objectively tenable, the court has determined that the fundamental interest which the malicious prosecution toward is designed to protect, the interest in freedom from unjustifiable and unreasonable litigation, has not been infringed by the initial action. Under such circumstances, it is not unfair to bar a plaintiff's suit for damages even if the plaintiff can show that its adversary's law firm did not realize how tenable the prior claim actually was, since the plaintiff could properly have been put to the very same burden of defending an identical claim if its adversary had simply consulted a different, more legally astute attorney. This is a classic case of no harm, no foul. Sheldon Appel, Supra, 47 calories. 3D at pages 881-882. In reaching this conclusion, the Supreme Court discussed a number of malicious prosecution cases in which the attorney defendants had been specifically charged with knowledge of the falsity of the claims asserted in the underlying action, e.g., Bertero v. National General Corporation 1974 13 Cal. 3D. 43, Franzen v. Shed 1923 192 calories 572, and Albertson v. Reboff 1956 46 calories. 2D 375. As the Supreme Court put it in Sheldon Appel, in each of those cases the plaintiff's contention was that the prior action had been prosecuted with knowledge of the falsity of the claim. Sheldon Appel, Supra, 47 calories. 3D at P. 880, include footnote 8. The re-evaluation of probable cause. Moreover, the fundamental interest protected by the malicious prosecution toward is freedom from unjustifiable and unreasonable litigation. Sheldon Appel, Supra, 47 calories. 3D at page 882. For this reason, even under the subjective belief standard rejected in Sheldon Appel, the question used to be whether the attorney had an honest belief that his client's claim was tenable, e.g. Tool Research and Engineering Corporation v. Henningsen 1975 46 calories. APP. 3D 675, 683, a jury verdict in the client's favor in the underlying case was conclusive evidence of the existence of probable cause, even though subsequently reversed. Cowles v. Carter 1981 115 calories. APP. 3D 350, 356. That rule was based on the notion that persons who initiate civil proceedings should not thereafter be subjected to malicious prosecution litigation unless it could be shown that they acted without probable cause, and that if probable cause had been determined by the trier of fact in the prior proceedings, it was not subject to re-evaluation even when the jury's determination was reversed. Hibbett, see also House v. McClelland 1951 102 calories. APP. 2D 762,764, Black v. Knight 1919 44 calories. APP. 756, 770, Lucchesi v. Giannini and Uniac 1984 158 calories. APP. 3D 777, 785, 788. The several references in Sheldon Appel to freedom from unjustifiable and unreasonable litigation suggest the continuing validity of the rule that a prior determination of probable cause cannot be second-guessed in a malicious prosecution action even where the judgment in the underlying action is reversed on appeal. It follows necessarily that where the record in the underlying action is equally complete albeit with a different ending, it constitutes all the evidence needed to determine whether the underlying action was objectively tenable when it was filed. Accordingly, there are no disputed facts concerning the record in the underlying action. The trial court may by summary judgment determine the probable cause issue, and the attorney's knowledge is entirely irrelevant. Standard for determining objective tenability after holding that an attorney's reasonable research and industrious investigation are legally irrelevant to the determination of probable cause. Sheldon Appel, Supra, 47 calories. 3D at pages 880 to 883, and that expert testimony is not admissible on the question of probable cause ID. At page 884, the Supreme Court concluded with the articulation of a standard for determining whether the underlying action was objectively tenable when filed. In Sheldon Appel, Supra, 47 calories. 3D at page 868, the California Supreme Court held that where there is no dispute as to the facts upon which an attorney acted in filing the prior action, the question whether there was probable cause to institute the prior action is purely illegal. Questions to be determined by the trial court on the basis of whether, as an objective matter, the prior action was legally tenable or not. If the court determines that the prior action was not objectively tenable, and thus concludes that the action was brought without probable cause, evidence of the extent of an attorney's legal research may be relevant to the further question of whether the prior action was instituted with malice. But if the court finds that the prior action was, in fact, tenable, probable cause is established, and the malicious prosecution action fails, without regard to the adequacy or inadequacy of the attorney's legal research efforts. Consideration of the actual holding of Sheldon Appel and of the Riso